The Rajya Sabha on December 8th passed the Wildlife Protection Amendment Bill 2022. The bill had been cleared in Lok Sabha in August during the monsoon session. However, the passing of the bill has invited scrutiny on two major issues. So, what are these two issues that we are talking about? Number one, the exemption made to allow the transfer of captive elephants. Number two, sweeping powers have been given to the centre to declare species as vermin. So in 1927, the Indian Forest Act listed the elephant as cattle. When WLPA was enacted in 1972, it identified the elephant as a vehicle. The elephant was given the highest legal protection in 1977 as it is the only animal in WLPA's schedule that can still be owned legally by means of inheritance or gift. The WLPA Amendment Bill 2021 proposed an exemption to Section 3. Quote unquote, this section shall not apply to the transfer or transport of any live elephant by a person having a certificate of ownership where such person has obtained prior permission from the state government on fulfillment of such conditions as may be prescribed by the central government. Now, this blanket exemption was vehemently objected to by conservation and animal welfare groups and also the Parliamentary Standing Committee headed by Congress leader Jairam Ramesh. They recommended the exemption be limited only to temple elephants kept for religious purposes. Now, the government has modified the exemption but worded the amended clauses vaguely. The exemption now reads, transfer or transport of a captive elephant for a religious or any other purpose by a person having a valid certificate of ownership shall be subject to such terms and conditions as may be prescribed by the central government. Critics point out that the sweeping ambit of any other purpose will empower elephant traders, put wild populations at greater risk of capture. Now, for lakhs of farmers in India, crop depredation by wild animals is the biggest challenge to livelihood and also an occasional threat to life. Since 1972, the WLPA has identified species like fruit bats, common crows and rats as vermin. Killing animals outside this list was allowed under two circumstances. Given sufficient reasons, any species other than those accorded the highest legal protection can be declared vermin at a certain place for a certain time. The Chief Wildlife Warden of a state can allow the killing of an animal irrespective of the status in the schedules if it becomes dangerous to human life. Now, the state governments took the decisions under Section 62 until 1991 when an amendment handed over the powers to the centre. And in recent years, however, the centre has started using its powers under Section 62 to issue sweeping orders declaring species as vermin. The decision was often taken without any credible scientific assessment. The issue has since entered the realm of centre-state politics, and this is precisely why the House was divided on the issue. While members of particular states highlighted the growing menace of wild animal attacks, others sought a more tempered and scientific approach in declaring a species as vermin.